Good afternoon. I welcome everybody to this afternoon's webinar training, part of the webinar training series here at the court, which is organized by the Criminal Law Group of the European Court of Human Rights in cooperation with Beyond Detention Interest Group, Liverpool John Moores University and Bologna University. I would like to immediately give the floor to Paolo Lobba for some introductory remarks, and then I will set the scene for today's event. Paolo, please.
Thank you, Mr. President. Good afternoon, everyone. Before I briefly introduce this webinar series, I should like to spend a few words of gratitude, both personally and on behalf of the other organizers, Judge Xenia Turkovic, who is also the president of the Criminal Law Group of the European Court of Human Rights, and Dr. Tristino Mariniello, senior lecturer at the Liverpool John Moores University. First of all, thank you, President Spano, for your support since the beginning of the organization of this event, and for having agreed to chair the first installment, the first webinar of our initiative. Let me next express my heartfelt gratitude to the Staff Training Office and the IT department for their excellent cooperation on the organization of this event. Special thanks in particular to Annie Armianova, Silvia Kurenko, Gail Michel, Marguerite Marty-Rosian, and Frank of IT department for their warm, patient, and constant support. At last, I would like to conclude by thanking the University of Bologna, the Liverpool John Moores University, and the Zagreb University, which are our partner universities, who have sponsored this event, and they have solicited the widest possible participation of students and scholars. I would like now to set out the structure and the overall theme of this initiative. This series of webinars has been conceived as an interface of dialogue between the court and the academia. Each of its 4 installments feature 2 speakers, one from the court, one from the academia, and one discussant with an academic profile as well. In this way, we intended to encourage an exchange of views, mutual fertilization between 2 worlds that have at times been criticized for not paying sufficient attention to each other. The webinars are thus meant to serve as a forum that brings together leading scholars, judges, and practitioners to discuss human rights standards. In the same vein, even though the webinars are in the first place training events for the court's lawyers, they also are open to the general public, and the general public may also contribute by making comments or asking questions through the live chat. Turning to the overarching theme of the series, the webinars will address a range of issues concerning the privation of liberty. We opted for this subject in spite of, or rather precisely because of, its fundamental character in defining the nature of criminal law. Criminal law today is pushing its limits through an expanded use of the privation of liberty. The privation of liberty has taken center stage in emergency control policies across the globe. For example, preventive detention is widely used both as a sweeping counterterrorism tool and as a measure of migration management. In these areas, growing recourse to detention raises concerns, not least because it escapes the usual range of safeguards recognized in criminal proceedings. But even aside from preventive detention, criminal law is extending beyond its traditional province, affecting increasingly more aspects of individual liberty. While new far-reaching provisions have been introduced in time of crisis, they are being incorporated into our legal systems. Emergency legislation has thus been normalized. In this context, we decided to raise various questions regarding the nature, aims, and scope of punishment and detention. What makes punishment human or just? When does a restrictive measure qualify as the privation of liberty? To what extent, if any, does a pandemic impose additional limits on recourse to detention? Which restraints must remain in place in time of emergency to rein in the broad discretionary powers vested in the police? These, as well as other questions, will be explored by our guests throughout the 4 webinars of the series. We are honored that many among the leading experts in the field have accepted our invitation, and I wish to thank them on behalf of all organizers. At last, before giving the floor back to the President, please let me recall our next appointments. On Thursday, April 22nd, we'll be addressing border crossing and the right to liberty. Next, on Thursday, May the 20th, we'll be speaking about detention during pandemic. On Thursday, 24th of June, police power and national emergency. All events are going to start at 4 p.m. Further information may be retrieved for staff members in the training workflow and for external participants in the web pages of our partner universities, Bologna, Liverpool, and Zagreb, or in the web page of Eventbrite. Thank you for your patient attention, and I have concluded, Mr. President. Thank you so much.
Thank you very much indeed, Paolo. Now we will immediately turn to our agenda. We have 2 speakers first to give addresses, Professor Dirk Vancil and Vice President Xenia Turkovic, followed by discussant Professor Bernard E. Harcourt. Each of them will have exactly 15 minutes and no more than 15 minutes, so we can have some time for discussions. The first speaker is Emeritus Professor of Comparative and International Penal Law at the University of Nottingham, Mr. Dirk Vancil. He has also been visiting professor at different universities in Europe and in the US. Professor Vancil has widely published on all aspects of sentencing and punishment, including their international and comparative applications. He has also served as an expert advisor to the Council of Europe on the European prison rules. He is the chair of Penal Reform International and is currently leading a research project on life imprisonment worldwide. Emeritus Professor, you have the floor.
Thank you very much, Judge Spano. Thank you very much to the organizers for the invitation, and thank you for the kind introduction. The topic, humane punishment, life imprisonment, and the right to hope, rightly celebrates the achievements of the European Court of Human Rights in the sphere of life imprisonment. This right to hope for a prisoner serving a life sentence refers to hope of being released. What is required, as the court has recognized, is that every life prisoner should have a realistic prospect of release, although, of course, that prospect may never be realized. Much good law has been built on this primary insight. However, there are still some shortcomings in the approach adopted by the court that I would like respectfully to discuss today. But first, the undoubtedly positive. Many of the life cases that the European Court has considered have involved the United Kingdom, and more specifically, England, where I live and work. A long line of earlier cases culminated in 2002 in the decision in Stafford against the United Kingdom, which, relying largely on Article 5.4 of the European Convention on Human Rights, established the necessity of due process in the consideration of the release of life prisoners immediately after they'd served the minimum period set by the court. This important decision led in the UK to clear legislation established that for the vast majority of lifers for whom minimum periods are set at sentence, release will be granted at the set time by a fully independent parole board. Among more recent cases, pride of place should be given to the decision of the Grand Chamber in Vancil against the United Kingdom. Here the court held that the prohibition in Article 3 of the Convention on Torture and Inhuman or Degrading Punishment encompassed the right to hope, also for sentenced prisoners with whole life orders, that is, sentences for which no minimum period had been set, after which their release would be considered. More concretely, The Winter judgment and the subsequent Grand Chamber judgment in Murray against the Netherlands put considerable flesh on the bare bones of the right to hope, by stating clearly that life sentences could not be implemented in ways that made the prospect of release impossible, either in law or in fact. Put differently, in the words of the Grand Chamber, a life sentence can remain compatible with Article 3 of the Convention only if there is both a prospect of release and a possibility of review, both of which must exist, and I emphasize this, from the imposition of the sentence. Close quotes. In fleshing out what is required in practice, the Grand Chamber commented that there's clear support for the institution of a dedicated mechanism guaranteeing a review no later than 25 years after the imposition of a life sentence, with further reviews afterwards, adding, however, that it was for states to decide what form that review should take. So, why is a re-evaluation of the continued implementation of a life sentence needed? The answer is that the Grand Chamber has found that a prisoner cannot continue to be detained unless there are legitimate penological grounds for incarceration, which include punishment, deterrence, public protection, and rehabilitation. While many of these grounds will be present at the time when a prisoner is sentenced, the balance of these justifications for detention is not necessarily static and might shift in the course of the execution of the life sentence. It's only by reassessing the justification for continued detention at an appropriate point in the sentence that these shifts can be evaluated properly. This reassessment must be based on, and I quote, rules having a sufficient degree of clarity and certainty, and the conditions laid down in domestic legislation must reflect the conditions set out in the court's case law. For good measure, the court added explicitly that the possibility of being granted a pardon or release on compassionate grounds for reasons related to ill health, physical incapacity, or old age, as described in the official English Lifer Manual, does not correspond to the notion of a prospect of release. And there was more in the judgments in Winter and Murray. The court explained that not only must there be sufficient procedural guarantees, but the prisoner must know from the time of sentence what he or she must do to be considered for release and under what conditions. This must be further safeguarded by the giving of reasons in judicial review. Finally, in assessing whether a life sentence is reducible de facto, it may be of relevance to take into account statistical information on prior use of the review mechanism in question, including the number of persons having been granted a pardon. So in sum, the Grand Chamber has developed a whole series of criteria it hasn't been shy to apply. Not only did it declare in Winter that the whole life imprisonment as implemented in England infringed Article 3, but in 2016 in Murray it found against the Netherlands for de facto not providing a prospect of release for a physically incapacitated prisoner who couldn't attend rehabilitative programs. Since then, other sections of the court have been active too, finding, for example, against Hungary in 2015, because it had set a minimum period of 40 years before life prisoners could apply for release, against Lithuania in 2017, Ukraine in 2019 for not having an appropriate release procedure, and against Italy also in 2019 for excluding consideration for release of members of the mafia who would not cooperate with the police, even if their reason was that they feared for their lives if they were to do so. The Winter judgment in particular has had a positive impact around the world, sometimes in unlikely places. In Zimbabwe, a brave judge relied on Winter to declare the unfettered power of President Mugabe to decide on the release of lifers to be unconstitutional. While in Belize, the Court of Appeal, also relying on Winter, struck down all whole life sentences and ordered the government to introduce a parole system applicable to all lifers, a judgment that was upheld by the multinational Caribbean Court of Justice, again with reliance on Winter. But in the United Kingdom, and particularly in England, things have unfortunately turned out very differently. The official reaction in 2013 to the Winter judgment was, if you'll allow for some English understatement, not positive. On the contrary, it was condemned in the strongest terms by the Secretary of State for Justice, the very politician who had and still has the power in England to decide whether whole life prisoners will be released. the Secretary of State indeed threatened to withdraw the UK from the European Convention on Human Rights. The British government did nothing at all to implement the Vancil judgment. Initially, the government believed that because of that, they could offer no defense to claims from other prisoners serving whole life sentences. And it told the European Court of Human Rights this in preliminary pleadings in another case of whole life imprisonment, that of Hutchinson against the United Kingdom, which by 2014 was making its course through the Strasbourg system. When I say that the British government did nothing, I mean that they didn't make prisoners with whole life sentences subject to the release decisions of the Parole Board like other life sentence prisoners. They left the existing statute, the legislation that provided that the Home Secretary may at any time release a life prisoner in place. And what the statute said, that it could release such a prisoner if he is satisfied that exceptional circumstances exist which would justify the prisoner's release on compassionate grounds. Exceptional circumstances and compassionate grounds. As is clear from this wording, this was simply a codification of the pardon powers exercised by the Minister of State on behalf of the sovereign. They left unaltered the provision of the so-called Lifer Manual that dealt with compassionate release solely on medical grounds, grounds that should only be considered when, and I quote, the prisoner is suffering from a terminal illness and death is likely to occur very shortly, or is bedridden or similarly incapacitated, and the risk of reoffending is minimal, and further imprisonment would reduce the prisoner's life expectancy, and there are adequate arrangements for the prisoner's care and treatment outside prison, and early release will bring some benefit to the prisoner or his family. The narrowness of this formulation and the failure to elaborate any other grounds underlines that what was being considered were truly exceptional circumstances that may require a compassionate pardon, and not the case of a prisoner with a whole life order who had done what was expected of him and whose continued detention needed to be reevaluated. In 2014, however, the English Court of Appeal came to the government's rescue. And in the case of Newell and McLaughlin, by interpreting the existing English legal framework, or reinterpreting it in a way that was compatible with the principles of that the Grand Chamber had developed in Venter and Murray. The Court of Appeal held that the Grand Chamber had placed too much emphasis on the Lifer Manual. The Secretary of State of Justice was not bound by it. The Court of Appeal was sure that the Secretary of State could and would apply Venter principles going forward when considering the release of lifers with whole life orders. A generous interpretation of the terms exceptional and compassionate in the primary legislation would, said the court, allow the Secretary of State to accommodate all the Venter principles. And, explained the Court of Appeal, if the Secretary of State didn't do so, he would be subject to judicial review. English trial judges, declared the court, could go on imposing life sentences with whole life orders. In England, this decision of the court was roundly criticised. The leading English criminal law scholar, Professor Andrew Ashworth, pointed out that even if the strictures of the Lifer Manual were ignored, a consideration of release on compassionate grounds in exceptional circumstances was not sufficiently broad to allow a full examination of whether there were legitimate penological grounds for the continued incarceration of a prisoner subject to a whole life order. I agree with Professor Ashworth. Moreover, there was nothing in the English legislation or of the judgment of the court to give the prisoner any guidance of when he could apply for review of his detention or what he would have to demonstrate. Unsurprisingly, in the light of this judgment, the UK court changed its tune. The UK government changed its tune in the Hutchinson case, which was already before the European Court, and now relied directly on its own Court of Appeal. When the Hutchinson decision finally reached the Grand Chamber in 2017, the Grand Chamber agreed with the English court and with the government, holding that English prisoners serving whole life sentences did now have a realistic prospect of release, even though there had been no legislative changes after Venter, and even though no one had been released. The court did add, however, that it would be a good idea if the Lifer Manual and other official sources of information were revised. The impact in England since the Hutchinson judgment in 2017 to now has been that the legitimacy of whole life sentences, understood as sentences from which no one will ever be released, except perhaps when they're at death's door, has been reinforced. The immediate response of the Secretary of State for Justice to the decision of the Grand Chamber in Hutchinson made it clear that the government did not intend to focus on releasing anyone subject to a whole life order. She, the Secretary of State, welcomed the judgment, not because it allowed her to apply the Winter criteria, but because Hutchinson indicated, she alleged, that it was right for those who'd committed the most heinous crimes to spend the rest of their lives behind bars. The Sun newspaper added gleefully, the new ruling confirms Britain can continue to keep beasts caged until they die. At sentence, English judges have continued to tell an increasing number of life prisoners in the bluntest terms that they are subject to whole life orders and that they will die in prison, with no mention that they may hope for release, let alone a reasonable prospect of release, if they grasp the opportunities of rehabilitation. There's been no new legislation setting out release criteria. Even the old lifer manual is still in place. Importantly, no prisoner serving a life sentence has been released, nor has any jurisprudence emerged to structure the Secretary of State's discretionary powers. Prison lawyers who've approached the Ministry of Justice to make representations on behalf of their clients have been given no guidance on what factors will be regarded as relevant, and told instead they should apply when and how they see fit. The possibility of judicial review is simply not enough to set this right, as the standards set by the Grand Chamber in Winter and Murray have not been met. On the contrary, since the decision in Hutchinson, successive Secretaries of State have called for and facilitated the increasing use of life sentences. Legislation now before Parliament will extend whole life sentences so that they can apply to anyone who murders a child. Present, only someone they can only be applied where there's a sexual or sadistic motive. In addition, for the first time, judges will now be given the power to impose whole life sentences on offenders aged 18 to 20. The background to this last development is that a court recently sentencing a 20-year-old terrorist felt that the existing law was not harsh enough. It had imposed a life sentence with a minimum of 55 years. And even after 55 years, the prisoner could only be released if the parole board agreed. In practice, few prisoners are released immediately after their minimum period, and many prisoners receive minimum periods of longer than 25 years. Another problem is the politicians who advocate and legislate for more possibilities to impose whole life sentences are the very people who will have to decide on releasing such prisoners. They don't even alert the public to the possibility of such releases. I don't have time to go into it now, but around the world, the Hutchinson decision has been grasped by those who want to introduce or protect whole life sentencing, life without parole, in other countries. In academic literature, the Hutchinson decision was criticized heavily because it was claimed that the Grand Chamber was setting strictest standards for other countries than it was setting for England. I don't want to go into that now, but I do want to mention it just to say that this is a widespread perception and one that undermines the legitimacy of the court. What I want to do finally is to focus briefly on how the perceived shortcomings of the Hutchinson decision could be remedied. Two suggestions. Firstly, the court should pay more attention in cases like these to what is really happening in the jurisdiction. Empirical evidence, including statistical and other information on prior use of the review mechanism in question, with consideration also of the number of persons having to be released, would enable the court to decide whether a particular release process meets all its criteria and is functioning to give life sentence prisoners in a jurisdiction a realistic de facto prospect of release. Secondly, the requirements for the release process should be strengthened, in my view, by applying to all life prisoners the standards set by the court for the application of Article 5.4 of the European Convention. Leaving aside the question of precedent, the argument is simply stated. Where a life prisoner may have reached the stage where the legitimate penological justifications for their sentence have evolved to the point that their continued detention would be disproportionate, decision needs to be taken on whether it is in fact disproportionate. Continuing to detain someone if their further detention has been found to be disproportionate is unlawful. Article 5.4 provides that the lawfulness of a person's detention shall be decided speedily by a court and his release ordered if the detention is not lawful. It should therefore be applied to all life prisoners, not only those who have life sentences with reasonable minimum periods. For the essence of legitimate life imprisonment is a realistic prospect of release for all such prisoners. An Article 5.4 compliant process will not only be more effective in organizing the procedural rules the court has developed very well around Article 3, but will also be widely regarded as more legitimate than any other alternative. Finally, recently the United Nations has taken steps publicly to address the serious human rights challenges posed by life imprisonment and whole life sentences in particular. The UN advocates rehabilitation and social reintegration of all offenders sentenced to life imprisonment, links it to the right to hope, and is committed to striving for practical solutions for ending life sentences that do not allow this. As in the words of the UN, they are clearly not in line with international human rights standards. I trust that the jurisprudence of the European Court of Human Rights will continue to contribute to the development of human rights standards that are clear and enforceable enough to prevent the abuse of the extraordinary power that the state, any state, exercises over persons serving life sentences. Thank you very much.
Thank you very much indeed, Professor, for that very comprehensive and knowledgeable overview. We turn immediately to my colleague and friend, Judge Professor Xenia Turkovic, who is the Vice President of the European Court of Human Rights. Since 1987, she has been lecturing on criminal law, criminology, victimology, and health law at the University of Zagreb, and she became a full professor there in 2008. She headed the group of experts in charge of drafting the new Croatian Criminal Code from 2009 to 2012. She has published several books, one law commentary, and over 50 papers in international and domestic journals. This is a field she is extremely knowledgeable about. Xenia, you have the floor.
Thank you very much. It's a great pleasure to participate in this webinar and to talk about the topic that is very dear to my heart. And when I was thinking how would I divide today's presentation, then I have decided to talk about three issues. And the first issue is the Winters criteria and the development of the case law related to life imprisonment, which is of course incremental and which we more or less follow from Kafkaris and pre-winter period, winter, and then post-winter case law, and I will tell something about that. Then, since we dedicated much time to the Hutchinson, and Hutchinson really provoked lots of reaction and negative reaction in the public, I thought, okay, I will dedicate some time to Hutchinson and the response and how I see the Hutchinson. And then, if I will have enough time, I would just like to flag certain things where I think that the court has made small and slight opening of the door for starting to question compatibility of life sentence with Article 3, because as we know, for now, we are always saying that it is compatible, and it is compatible with Article 3. So when we are talking about the Kafkaris and the pre-winter case law, there it was confirmed that the convention does not prohibit the imposition of life sentence, so it is possible and it is legal, it is in compliance with the convention. But in Kafkaris, the court for the first time established that the imposition of a life sentence, if it is irreducible, if prisoner is held without any prospect of release, would constitute a degrading treatment and thus violate Article 3 of the Convention. In Streicher, the court said, a state cannot deprive the applicant of all hope of release or reduction of sentence. And as a result, and what is usually said and repeated in the case law, Kafkaris, Winter, Mare, Hutchinson, all Grain Chamber judgments, a life sentence does not become irreducible by the mere fact that in practice it may be served in full, so it may be served in full. The state should provide some possibility of review, allowing for the consideration of release, and no issue arises under Article 3 if a life sentence is de jure and de facto reducible. And after Kafkaris, the court really didn't do very high level of scrutiny, and in Kafkaris itself, the 5 judges, Tulkens, Cabral, Barreto, Fura, Sondstrom, Spielmann, and Jebens, criticized heavily Kafkaris and saying that actually the release could be limited, but it still must be genuine, that there should be adequate safeguards against arbitrariness, that there are a number of shortcomings in Cyprus system, no published procedure or criteria, no obligation for president to give reasons for his decision, and a refusal to order early release is not amenable to judicial review. That was their critique based on the international documents and comparative practice. And as you can see, all of this has found its way in few years in Winter. And Winter really relying on international documents and comparative practice introduced and expanded, actually we can say elaborated what was somehow embryonic in Kafkaris and established something that we call Winter standards. And when we are talking about Winter standards, we can talk about 3 types or 3 groups of standards, actually, I would say. Substantive requirements that are related to life sentence, then requirements that are related to prospect of release, and requirements that are related to prospect of review. So when we are talking about the substantive requirements, then we could see and we could take out from the case law that life sentence could be imposed on an adult offender. And the court is repeating that all the time. So a contrario cannot be imposed on somebody who is not an adult. That it could be imposed on those convicted of especially serious crimes. And if this is not so, and if the sentence is grossly disproportionate, that would be contrary to Article 3. The court has also said that this is particularly so. So the life sentence is acceptable if the sentence is not mandatory. So the court by now didn't say that it should not be mandatory, but still has showed clear preference for individualized punishment. And the court has said that the prisoner cannot be detained unless there are legitimate penological grounds for incarceration, which include, as the professor said, punishment, retribution, we call it, deterrence, public protection, and rehabilitation. And from what is written, actually, we could conclude that the retribution and deterrence in itself might be by itself sufficient only until a certain period of time, and that is roughly somewhere where 25 years come. After that, the person and the person could be imprisoned only if the person still poses the danger, if rehabilitation didn't do its work. And the court, of course, didn't precisely define that time. It is somewhere in between 25, and it is clear that it's not 40 years, and it is much closer to 25 years than 40. So after expiration of that time, person can be kept, as I have said, in prison only if he or she is dangerous for the society. So there is a positive obligation of the state to protect society from dangerous persons. State may fulfill that obligation by continuing to detain such life sentence prisoners for as long as they remain dangerous. However, there is obligation on the state to protect human dignity of prisoners and not to keep them in prison once the requirement of retribution has been fulfilled if they do not pose any more danger for the society. Punishment should be just and proportionate, and right to hope should be secured and guaranteed. So this is related to to these substantive requirements. Then there are requirements related, as I have said, to prospect of release and possibility of review. And as Professor Zint has emphasized, both of these requirements must exist from the imposition of sentence. Criteria, conditions, and assessment must be based on rules having sufficient degree of clarity and certainty, and these rules must reflect the relevant case law of the court, must meet standards laid down by the court. And certainty in this area is not there only because it is a requirement of the rule of law, but it is there because it also underpins the process of rehabilitation, which risks being impeded if the procedure of sentence review and the prospects of release are unclear or uncertain. When we are talking about the prospect of release, then the relevant case law is Winter and especially Murray. Murray bringing general principles and then particularly dealing with prisoners with mental health problems. And there it is underlined that the person has to have the possibility, and this is a genuine possibility, to rehabilitate themselves. This is the wording, rehabilitate themselves. The state is not rehabilitating them, they are rehabilitating themselves, but the state has to give the possibility for that. And this is obligation of means, not of result. It is there because of the prospect of release, but it is there also to protect the society. What that embraces, and by now the court has said, there should be individualized sentence plans, they should be drawn and periodically assessed. We find that in Winter and in Murray. Social rehabilitation programs, visits, conditions that do not lead to personal degeneration. This is the word the court used in Matiošaitis versus Lithuania. Should be detained, prisoners should be detained under such conditions and be provided such treatment that they are given a realistic opportunity to rehabilitate themselves. If a highly restrictive prison regime is imposed, automatic isolation of all life prisoners, or spending the whole day in the cell was found in Harkachieva and Tolumov, Petukohov, and Matiošaitis, violating the convention, and I would not go further into it. And then the third area, as I have said, is a possibility of review, and I won't go now in that because I do believe that the main authority for that is actually Hutchinson, that was so much criticized. And then when we are looking at the Hutchinson critique, then what is usually said? That Hutchinson created confusion, that it watered down standards. That it watered down the standards. It is saying one thing and doing other thing. Double standards, one standards for UK and other standards for Eastern European countries. Bowing to political pressure, willing to give great leeway to some states, greater lever to some states than the others. So I will try to demonstrate that actually Hutchinson could leave that critique and that the Hutchinson actually meant to do something else. 5 minutes, and I can do it in 5 minutes. So Hutchinson is dealing with the idea, is dealing with life sentence, but actually Hutchinson could deal with whatever. The topic could be whatever. When that case came in front of the court, actually it came before Winter, and it was very unlucky that the court came with Winter in front of the Grand Chamber and didn't join these two cases. So I would say that that was a mistake on the side of the court. But unfortunately, after that, the court had to deal with that issue. So what is actually the point in Hutchinson? In Hutchinson, the question is whether UK has implemented Winter judgment. And it is the question of the, whether it has implemented the Winter judgment and whether what we see that it exists in UK could be acceptable from the perspective of Winter standards and Winter principles. And as Professor Zint said, at the domestic level in the UK, there was a great reluctance on the political level to implement Winter. At the same time, we had the cases that were decided related to the prisoner ward that at the time were not implemented. And so there was that perspective, and you know, that would be the judgment that would not be implemented either. So the question is, you know, what do we have in front of us? And when we are looking at this, what we have got from the domestic authorities in terms of the implementation of the winter. And as you have said, the appeals court came and jumped in a way to save the situation. This is the time when in the court, highly on the agenda is the issue of subsidiarity and dialogue between the courts. So what we are looking at, Human Rights Act is there, and the domestic courts are, a domestic court is, of course, relying on Human Rights Act. And what is domestic court telling to us? The domestic court is telling to Strasbourg that, okay, when we are applying acts, they could be primary legislation or secondary legislation, and when the primary legislation is looked at, then if the primary legislation could be interpreted in a way that accommodates principles coming from the convention, then that law is sustainable and it is applied in that way. And the appellate court said, yes, we can interpret, and we would, and we do interpret the provision S30 of the 2003 Act in compliance with the convention standards. What else domestic courts have said? They have said, well, there is lifer manual. This is even not a secondary legislation. This is a policy. So it's even not a secondary legislation. And of course, this is regulating only one segment, and that doesn't mean that we won't apply this to all other segments that are not actually covered by that policy. So you have Human Rights Act, which is actually an excellent document on how convention is implemented domestically, and the courts are interpreting winter in accordance with the Act, with the Human Rights Act. So what was the question actually for the court? The first question was, could we trust appellate court that they will do that? And frankly, there is nothing there are no basis for Strasbourg to say we do not trust appellate court when they say that they will apply the domestic legislation in compliance with the Human Rights Act, and that according to the Human Rights Act that they can interpret domestic legislation in that way. It is for them primarily to interpret domestic legislation, not for us. Then what is the question then? They say they will be interpret the legislation in accordance with the winter criteria laid down by the court. Of course, they didn't say the same thing as what they have said in Bieber, because in Bieber they said only what was related to Kafkaris. So when we had winter and coming with winter judgments, Bieber could not be satisfactory for us. And so when we are coming to winter, of course, to winter and then to Hutchinson, of course, Bieber is not satisfactory, but appellate court made a move in McLaughlin and has said, okay, we are doing this, exceptional circumstances are interpreted as in the court's case law, this is interpreted as in the courts, and so on and so forth. And in winter, the court, I will finish in a minute. And in winter, the only thing that the court did when it was analyzing domestic legal system was saying there is discrepancy, there is the confusion. But it didn't analyze it in substantive way, in any substantive way, and found violation only on basis of that. So when we are coming to the Hutchinson, what was actually the question for Hutchinson? If the convention is directly applied at the domestic level, we had to ask ourselves whether the convention is precise enough that it could be applied at the domestic level. So if you are looking at what is done in Hutchinson, Hutchinson is very carefully going through all the principles, not only in winter, but all the principles that exist, and is pulling them there and is defining them so precisely that when you read Hutchinson, you precisely know what is required. So if you don't have that at the domestic level, the court is providing that for you, and the court is questioning itself whether case law of the court is precise enough. And at the end of all of this, the court came to the conclusion, yes, it is precise enough. So if they are implementing and if they would do that, they can do it, it is precise enough. And then the court didn't find a violation for the period before winter, but simply said, yes, the situation was the same. The court is actually doing the abstract review of law. How many times would you find a violation on the abstract review of law? There is enough to do it once. We said that before. Hutchinson in, what's the name of the Slovak case?
Professor Harkov.
Yes, I'm here. Okay.
Even 10 minutes.
Okay.
He has already started.
Okay, I'm stopping. And the same thing we repeated and did in the last case in Lithuania, where we looked at how the court has, domestic authorities have implemented Matthew Saidis' judgment. Thank you.
Thank you very much. And sorry for that, because we have Professor Harcourt who has to actually leave in 9 minutes. So I would give him immediately the floor, Professor Harcourt. Let me just say a few words about your background and your current position. You are a professor of law and professor of political science at Columbia Law School in New York. You have extensive, I see, knowledge. You have author of several publications on punishment practices in political economy, critical theory and practice. Please, you have the floor.
Thank you. And can you hear me well? Yes? Yes.
Very
okay.
well. Go ahead.
Thank you. Thank you. Thank you, President Spano. Thank you, Vice President Turkovic. Thank you, Professor Vancil Smith, and thank you, Paolo Loba, for inviting me. I do apologize. I must have understood incorrectly, but I thought we were going from 4 to 5 p.m. Strasbourg time, and I do have to be in court in North Dakota on a standing rock case, so I will jump off. I'll be quick, and I will try to present as quickly as I can. I assume that when you were asking me to participate, you were asking for an outside perspective. I am an outsider in many ways. I work on American legal doctrine, not human rights. I'm not like my colleague, the brilliant Sarah Cleveland or Samuel Moyn. I also, in the United States, fight against a doctrine and do not support the American kind of exceptionalist views. So I come to you a little bit like Candide, Voltaire's Candide, who you will recall spent a long journey visiting places he had never seen, only to return home to decide that actually he should be cultivating his own garden. As an outsider, I have dueling reactions, both to the papers, but also to the case law that I've been reading. The first is utter respect and amazement. The right to hope, for instance, is an extraordinary right that does not exist in the United States. We are so far from that, and I have such respect and admiration for that. As I was reading the paper from Professor Smith and reading the case law, I received a letter from a client of mine, Philip Tomlin, 67 years old. He's been in prison for 44 years, 27 of which on death row. He's serving a life imprisonment without parole. And I could only think of this passage in this letter where he writes to me, I have to do something. I can't just sit here and rot and wait to die years from now. And he's speaking about life imprisonment without parole. This was an unsolicited letter I received on March 6, 21. He talks about, we have a basketball court and weight piles, but I'm beyond those. Of course, he's 67, and I don't watch much TV except for these news. I have to do something. And so I have the utmost and greatest respect for much of the jurisprudence. At the same time, in the same way in which Professor Smith was speaking about both the progress but also the work that needs to be done, I will confess that at times I almost felt as if the right to hope is perhaps too limited today. And so I wanted to say something about that. I understand that I really don't have any standing to stand on as an American. We execute people. We confine people to life imprisonment without parole, solitary confinement for years on end. We detain indefinitely at Guantanamo. In fact, I'm litigating a case on behalf of a client at Guantanamo. Latif Nasser, who and we're trying to get due process rights. And even, I don't know if you know, but the District of Columbia Circuit Court, which is one of the highest courts, I mean, the second highest court in the United States, declared that there are no due process rights at all at Guantanamo. So I understand I don't have much standing, but sometimes when one has no ground to stand on, one has a different perspective, maybe sometimes a better perspective. And from this country right now, I'm experiencing a different path forward, one that in a way outstrips the due process model in the United States, but also may be kind of devancing the human rights model in a way. And it's grounded instead on notions of reconstruction, of social reconstruction, or on what W.E.B. Du Bois, the famous philosopher, called abolition democracy. As you know, there's been remarkable turmoil in this country, and there is a new national debate over whether to reform or to abolish the core institutions and practices of what was conventionally called the criminal justice system, the police, prisons, etc. Of course, many people are hesitant and think that it's actually driving a wedge within progressive communities. Former President Barack Obama was expressing his sentiment, his critique of the idea of defunding the police in this country. But I would say that far from being a distraction, the emerging debate is actually one of the most productive developments in the penal law in this country, because it is forcing us to ask probably the single most important question at the heart of penal law, namely, whether the institutions, practices, and agents of the penal law function or should function to redress the harms associated with crime, or instead whether they serve primarily to impose a social and racial order. In this country, clearly an unjust racial order. That question is so important because it focuses us to confront what the institutions and practices of the penal law are doing and what they would look like if they weren't tainted in the way that they are. A lot of this draws on the path-breaking study, Black Reconstruction in America, that Du Bois published in 1935, where he demonstrated how the use of Black codes, the use of convict leasing, the use of plantation prisons were in effect actually a way to re-enslave freed Black women and men in this country. And of course, many are returning to those ideas. They are receiving much more attention right now with Mariam Kaba's new book, which was just published, We Do This Till We Free Us, and it's on the New York Times bestseller with Dorothy Roberts, a professor at Pennsylvania, University of Pennsylvania, just writing the foreword to the Harvard Law Review's esteemed survey under the title Abolition Constitutionalism, with Ruth Wilson Gilmore in the pages of the New York Times, and so many others, Amna Akbar, Alexis Hogue, Allegra McLeod, Dereka Purnell, and others, nourishing this debate and asking us to really question what in fact, whether those purposes, Judge, we were just talking about in terms of rehabilitation, incapacitation, deterrence, etc., whether those purposes are really mean anything, or whether punishment has become a form of governing. Professor Smith expressed some concern that in extradition matters, the Vintner standard that was applied in the Trabelsi case will not be applied in the future. I read the Trabelsi case in preparation for our discussion, and it's a laudable legal holding where extradition is not allowed. There's no doubt that Mr. Trabelsi will be held life imprisonment without parole in this country. There's simply no doubt about that. But what I worried about the decision wasn't so much Professor Schmidt's question about whether it will be applied in the future, but the remedy in that case. And if I understood correctly, as I read the Just Satisfaction Article 41 of that opinion, it said that the court held that Belgium was to pay the applicant 60,000 euros. And I just wondered whether that was what that means, really, 60,000 euros for someone who will spend the rest of their natural life incarcerated in prison in the United States under conditions which can be egregious. I can imagine it would provide some snacks from the canteen for a few years, but not much more. And so we are in this country in a different place, I think, in our debates, casting a whole new light on the rights paradigm. And for me today, even both on the due process, but also on the human rights paradigm. And the efforts to find just punishment, it seems, in many cases, turn out later to be defenses of unjust punishment. And so I will leave you with those thoughts. It leaves me whether the discourse is ultimately co-opted by government if they are asked only to pay $60,000, but are allowed to engage in these forms of transfers. And it leaves me, of course, with some deeply conflicting thoughts. I will end here. I apologize again for my misunderstanding about the timing, and I will fly very quickly to North Dakota, and I thank you.
Thank you very much indeed, Professor Harcourt, and also for taking the time to be with us here this afternoon. Indeed, many of the issues that you have mentioned cast a very interesting light on what one can say is the transatlantic dichotomy in this field, which, as you know, the court has often been struggling with ever since Suring versus the UK. You mentioned Trabelsi versus Belgium, and those are some of the elements. The extraterritorial application of Article 3, which is an extra element to what we have been discussing. Thank you very much indeed, and best of luck in your current practices in the U.S.
Thank you, President Spano.
We now will turn to questions and answers. We have some time, and I do hope we will have questions to Vice President Turkovic and Professor Still-Smith about some of the elements that have been raised. Let me just myself maybe pose a couple of questions at the outset, directing them as me and Xenia, of course, are in the building together and have spoken about these issues quite often. I'm intrigued by some of the elements mentioned by Professor Still-Smith. One of the elements that I'm wondering about is the issue of the remedy or the review mechanism under the Winter Doctrine. As you have seen from the development of the case law, that prong of the procedural remedy required in a whole life system has, of course, gone through quite a development since Winter. I mean, Winter is the forced foray, of course, after Kafkaris. Winter proceeds with a particular framework, which is then fleshed out in some of the later judgments. Hutchinson is, of course, one element of that. Murray versus the Netherlands is another. Another indeed is Mateuszaitis versus Lithuania. I just wanted to ask you, Professor Still-Smith, your reference to Article 5.4, to what extent do you believe that the court's current case law on this issue, when it comes to the requirement of review of executive decision-making, does not go far enough? And could you clarify a bit, when you make a reference to 5.4, is it your view that a review mechanism, a judicial review mechanism, is an absolute requirement for any domestic system to pass muster under Article 3 and the Winter Doctrine, or is a system based on executive decision-making, where all of the salient features of the decisions by, for example, a parole board can be made by the parole board itself, and whether there is judicial review does not, in effect, have to be the be-all and end-all of all the system? I have then another question which has been posed by a participant, but if I may, on this first, Professor Still-Smith, and of course, Vice President Turkovic can also comment.
Well, thank you very much for that question. The answer is...
Professor, are you there?
Yes, I am. Can you hear me? You should be able to. My microphone is on.
Left us.
Okay. Can you hear me?
Did you hear my question?
Yes, absolutely. Yes, I heard you perfectly. The answer is a nuanced one. I've done a lot of comparative work on this, and in my book with Catherine Appleton, I try and isolate three different approaches. the judicial one, a parole board, and a narrowly executive decision. And the answer in the abstract would be the following. I think that there is great reason for having a judicial decision, simply because of the enormous pressure that politicians face. And I think the post-Hutchinson experience illustrates it. You are expecting politicians who've made their career by saying, we're going to keep these people in prison until they die there, to make a decision on release. And I think that's the worst of all worlds. I do think, however, that it's possible to have a mixed sort of bench. And in an early decision of the European Court, it actually declared the English Parole Board to be a court-like body. The English Parole Board isn't perfect, but typically when it sits in a case deciding on the release of someone after a minimum period, it is chaired by a judge, and you then have a psychiatrist and one other member. So there is scope for maneuver, there's scope for a mixed bench in this area, which could do things better than a narrow court. An example I give in my book of a narrow court that would not work, you can say, well, every court would decide these cases after 25 years, but tucked away in the legislation, I think this is true in the Russian case, is a rule which says if you have a disciplinary conviction against you in prison, your case is not heard by a court after 25 years. So the detail matters. If I could just apply this again to the post-Hutchinson situation. The difficulty you have in England is that these whole life sentences are more severe sentences than those for which a tariff has been set. The English courts comfortably set tariffs of over 30 years. There are more than 100 people serving minimum periods of more than 30 years. The whole life sentence is only used for cases which are regarded as worse than that need even longer minimum periods. So although it is attractive to say, well, in theory, you can go to, as the court did in McLaughlin, in theory, you can have a review at any stage. That is not working in practice. And I think the real difficulty in Hutchinson was that the court did not look enough at practice. Now, I can understand why it happened, but I think that some years on, you're going to have, with respect, this problem is likely to rise again. Finally, the reason for wanting a Article 5 type procedure, which was something which was raised in passing by Judge Bratzer in Kafkaris, is that would allow the court a way to organize these different doctrines and to say, what do we really need in a life sentence? Because fundamentally, all life sentences are different to determinate sentences. In the determinate sentence, the power of the state at the end of the day is limited by the end of the period. If you have indeterminate sentences, the state has enormous power. And therefore, I personally think very strict controls by a court or court-like body are necessary. Sorry, quite a long answer.
Xenia, did you want to add? Then I have one more question to pose to you.
I can just add, I didn't come to that, but I wanted to finish with the concurring opinion by Bratzer and in Kafkaris, and he said two interesting things there. One was that you have mentioned, and I think that this is something that in the future, the court will really have to look seriously. The court is moving slowly, I would say, in that direction. I think if we are looking at and this last judgment versus Lithuania, there it was said that the violation is there because there is no possibility of the access to judicial review when you have the possibility of review by the executive. So kind of two steps, what we also see in UK. So there is a move. This is for the first time when that was really said in this way. So we can see that the court is in a way moving in that direction. I also agree with you that the court will have to deal and will get the case after Hutchinson, and we will deal with the UK situation. But unfortunately, Hutchinson came just so too close to winter, and there was no really, there was actually when the court started to deal with it, it was a year and a half after winter, so there was really no point to look at the case law. There was no case law simply, and that's why the court didn't do that in that case.
Thank you very much. Before I pose the next question, it's interesting to see that the title of this webinar series today is Human Punishment, Life Imprisonment, and the Right to Hope. May I just make potentially the banal point that the European Court of Human Rights has never used the concept of the right to hope, number one. This derives from a concurring opinion of Judge Ann Power Ford in Winter, which has then in academic literature been sort of construed narratively as what the holding of Winter is. But to be clear, never has the Grand Chamber nor chamber judgments of the court ever used the concept of the right to hope. I think to some extent that it sort of eclipses a bit the debate we're having, because it is a debate about should the development end with, in fact, the abolition of life imprisonment under Article 3. Judge Turkovic didn't come to her third part. She may come to that now. Before that, may I ask this question, or pose this question, which is sent by one of our participants. How should the court deal with a complaint from a life prisoner against a state which did not introduce a dedicated review mechanism until after Winter, at which point this prisoner had already served, say, 20 years, and had thus not had a prospect of review and release from the moment of imposition? Xenia, would you start, and maybe then I come to the professor?
It is a tough question, and this is something that the court started in a way to deal in Hutchinson with that, and in other cases, in two other cases, and that is the issue, how the case, how the judgments of the court are implemented, and when the judgment is whether they can go retroactively, that's the whole issue, and that's the big issue. And I think this is the issue that the court at certain moment will have to grapple with and will have to deal with. And this is not only related to, this is a general issue, I would say, what the court up to now has done. So you can see in Hutchinson, we were obviously discussing the issue. It could be seen from the judgment, because the judgment has said that one sentence which says the Hutchinson is limited only to the period after McLaughlin, and the situation of the person of the Hutchinson is not different from the Winter. So in a way, the court was acknowledging during that time there was, of course, the violation. But this is abstract review of law, and then you can have 20,000 of people coming just telling all the time that the law at the domestic level was wrong. So you won't go 20,000 times to say that the law was wrong. And that's why it is very strange when this court is doing abstract review of law. I mean, that puts us in a little bit strange situation. We do that quite rarely, but this is one situation where we come very close to doing abstract review of law. Close, not exactly, but very close to it. So the short answer could be, okay, the court could acknowledge that there was violation prior to that time, but what the court would actually look, I think, at and should look at maybe, and did look, for example, in Slovak case, the court was looking how soon after the Winter the change in the law has been done. Because, we have moved from the time where we said the decision or the judgment that is made is applicable only to the country against which the judgment has been made. Now we are saying, we make a judgment, and if it is clear that this is the case law, then you should change your law and you should adjust to, even if this is a judgment that is not against your state. So that what was the court doing in the Slovak case, and said, well, they changed it within a year or a year and a half, and it's fine, no violation. Now in this Lithuanian case that came after the M case, as well, the court was looking and said, okay, all the adjustments have been done, and no violation. You see, so it's not going to tell again and again during that period. And I think this is a sensible solution, if you ask me, when we are at that level, when we are deciding practically in the abstract. So I would say then my answer shortly would be, depends how shortly after the winter the change has been made.
Professor Smith, please.
I'm so pleased the judge answered that question first, because it was a really tricky one. And I have very little to add, except perhaps a related point. We talk about a limit around about 25 years. But the question, which I know is a particular question in the Netherlands, is what do we mean by 25 years? Is 25 years when we start considering release? Or is 25 years, as is the law in some countries, the point at which we examine the prisoner and decide should this prisoner be put on a course which could eventually lead to release, which means that realistically the minimum period that you're looking at in any case becomes 25 years plus 10 or 15 further years before they've had a chance to give that person training. And I know that's not precisely what was being asked here, but it does relate to it. For the rest, I think the judge's expertise, with great respect, is clearer than I could do it.
Maybe just then a final question before I would briefly sum up. It is a related question, and it will allow Judge Turkovic to come to her third point, which is an interesting one. It's a question from Davor Derencinovic. Despite the nuances from Kafkaris to Hutchinson, very well explained by both speakers, it seems to me that we have a more fundamental problem. How to convince policymakers that introducing life imprisonment without possibility of parole would contravene the European Convention on Human Rights. Xenia.
This is, thank you, Davor, for posing that question. This is my colleague from the university and professor of criminal law as well. And certainly this is a big issue, and it is a big issue, especially in the environment in which we are living. And with growing populism, and where criminal law is more and more used as to gain political support, and to flag and to demonstrate yourself as a big fighter for the rights, or against the criminals, or against this or against that. So it's really a tough one, and actually in this area is always much better if this is left to the experts, but unfortunately nowadays this is such a rare occasion. Davor knows very well, we were drafting penal code together in Croatia, and in Croatia we don't have life sentence, and while we were drafting the penal code, there was certain pressure to introduce life sentence, but the commission that was working on it opposed to that, and at the end we did prevail, and we succeeded, contrary to Serbia that you mentioned in your paper but you didn't mention in your speech, where we are coming from the same same roots. There they have introduced the life sentence. So yes, it is something that requires lots of work on the public, and then the trust to the experts, and lots of education, I would say. Lots of education, the same as with the death penalty. We see even now, for example, where the death penalty for such a long time in Europe is not the issue, but if you do the survey, you would see that there is a great percentage of people who would like to reintroduce the death penalty, although it is not there for a long time now. So, just work and education. I don't know what else. Thank you.
I wonder if I could. Yeah, I wonder if I could add on this. I had more in my lecture on it and cut it out. And in fact, last year I gave the Roger Hood lecture at Oxford. And if one goes on the website, and I say this for people who may be listening, if you go on the website of the Centre for Criminology in Oxford, you'd find the lecture, because I dealt there very extensively with the Serbian case. I was fortunate enough last year, just before I retired, to have a very good Serbian student who could translate the Serbian debates for me. And what I discovered there, and this does bring it back to my lecture, somewhat distressingly, was that English law was being quoted as an example where you could still impose whole life sentences, where you could still impose life without parole sentences. We've focused mostly today on how you release from them. But the message that the McLaughlin/Hutchinson verdict conveyed in England was that judges were now free to impose these sentences again. I did say that in my lecture. The judges, I started looking at what judges say to people when they sentence them. They call them up and they say, your crime is so bad, I can set no minimum period at all. I'm giving you a whole life sentence, which means you will die in prison. Take him away. And it's as brutal as that. And that approach got picked up in Serbia. So in the long debates that I could read only in translation, and which were somewhat a bit confused, that mood got across. And I suppose when we talk about the European Court's role, the difficulty is, and it's not, I'm not blaming anybody. I was one of the lawyers in the Winter case, and we didn't argue against the imposition of whole life sentences. It wasn't what we were there for. But the reality is the European Court has never said you can't impose a whole life sentence. It has just said, in Hutchinson at least, as long as you have proper review, that's fine. And I think that's where the message gets confused. I was nervous about making this point because obviously I'm speaking to judges who've been involved directly in this case. And one can make an intellectual defense of the Hutchinson decision. But the reality is that the way it's come across is English judges say, right, we can impose whole life sentences again. What happens afterwards? Well, that's a problem for the future. And that was picked up in Serbia and also in Poland in the debates where people have moved towards introducing whole life sentences. And that is a problem, I think.
Thank you very much. Just there is a final question which I would pose because we are running out of time. Just a comment of mine in light of Xenia Turkovic's answer as regards Hutchinson and McLaughlin. I think it's important to realize, and the chronology here is very important. You have a judgment rendered by the Grand Chamber in Winter, approximately 2013. You have a few months later a judgment by the Court of Appeal in McLaughlin, which happens in February 2014, which is, let's be clear, it is an attempt by a Court of Appeal of England and Wales to clarify the scope and content of English law. Subsequently, Hutchinson is decided by this court. The fundamental components of the criticism is one which relates to what does this actually mean in practice? How is this fleshed out? How is the McLaughlin doctrine, let's call it that, how is that actually operationalized in English law? And does the Hutchinson court, does the Grand Chamber, when it accepts the doctrine of English law as clarified by McLaughlin, actually present a realistic view of the future of English law in this field? And as Xenia said, I think that will be for future cases. It is now for the English legal system to demonstrate that McLaughlin meant what it said and that it actually operates in that way. So in that sense, to criticize, and now I talk a bit like me and Xenia, we have to defend our court, of course. So to criticize Hutchinson itself at that point in time is, I think, perhaps a bit of an overstatement, because it is open, and it is always open for applicants in future cases to demonstrate with arguments that some premises, even of a Grand Chamber judgment, some factual and legal premises may be called into question. That is the evolving organic case law of the court. Finally, if I may, there is a question from Spain. well, at least by it seems to be a Spanish participant. Spain brought back life imprisonment with a 25-year tariff, while their constitution also protects against custodial sentences contrary to rehabilitation and reintegration. Would the court consider an advisory opinion on whether the 25-year threshold is a limit and not a start? Xenia.
Well, that I cannot say. That will be asked to the court, and then we will see what the panel will decide on that, of 5 judges. So that I cannot say. But I would like to use that opportunity to say something else then. First, to invite, in terms of the Hutchinson, I think that the UK lawyers actually should use for their benefit Hutchinson, and reinforce the principles that are in Hutchinson and all the principles that are developed in Winter, because domestic authorities said this is what we are applying. So now you can come to them and say, look, are you really applying all these Winter principles? And they said that they will apply them. And we said also as a court, as they developed. So not only statically as they were at the time that Hutchinson was there. So this is very interesting. This is actually stronger than anything else in any other country, I would say. So use that, use that to your benefit. And then in terms of what I wanted to say, compatibility of life sentence with Article 3. And then if we are looking at that, then, as I have said, Judge Brazza and Kafkaris, in his concurring opinion, said what we have said about Article 5.4. But then he said this, and I would like to end with that. He said, experience shows that 9 years, 10 years, or thereabouts is the maximum period of confinement that normal human beings can undergo without their personality decaying. They're becoming progressively less able to re-enter society and look after themselves and become useful citizens. So when Davor asked, well, this is something that we should transmit, that people understand that. The court often reiterates in relation to prisoners that suffering must not go beyond that inevitable associated with the legitimate requirements of the sentence. However, once it is accepted that the legitimate requirements of the sentence entail reintegration, questions may be asked as to whether a term of imprisonment that jeopardizes that aim is not in itself capable of constituting inhuman and degrading treatment. I consider that the time has come when the court should clearly affirm that the imposition of an irreducible life sentence, even on an adult offender, is in principle inconsistent with Article 3 of the Convention. And then that was confirmed and accepted by Judges Tulkens, Gabriele Barreto, Furas, Sanderstrom, Spillman, and Ebens in their concurring opinion. And then where the court has come the closest to that, it is in the judgment that is not directly related to that. So we had another very tough judgment in front of that court that was against Russia. That was Kamatuka versus Russia, where the question was, whether it is a discrimination that you can impose life sentence to men, but you cannot impose life sentence to young people younger than 18 and older people and women. And it is a tough cookie, really, and you could see. And then the majority at the end concluded that there is no violation. And I wrote a concurring opinion on that because I thought, it is really, really a tough cookie. And then I said, well, from the beginning, I was looking at that case from a completely different point of view. I was not looking at that case as the case of discrimination. I was looking at that case as the case where you start to abolish the life sentence. No, we are there. And then what the court has said, for example, since the delicate issue raised in the present case touch on areas where there is little common ground amongst the member states of the Council of Europe, and generally speaking, the law appears to be in transitional stage. So somehow court sees that there is some light in that tunnel, but we are still far away from it. A wide margin of appreciation must be left to the authorities of each state. And then it said, it therefore appears difficult to criticize the Russian legislature for having established in a way which reflects the evolution of society, so abolishment is evolution of the society in that sphere, the exemption of certain groups of offenders from life imprisonment. Such an exemption represents, all things considered, social progress in penological matters. So the court sent quite strong message in this respect in a case in which was deciding actually about something else in a way. Thank you.
I was just about to say, when we talk about the complete abolition of life imprisonment under Article 3 as a potential interpretation, it reminds me of the developments of Justice Blackmun and Brennan in the U.S. Supreme Court, and now the current Justice Breyer, who has also come to the view that the time has come to consider the death penalty as unconstitutional in the U.S. As regards the question by Pablo Sartoris, let me just say, with all the caveats just mentioned by Judge Turkovic, Protocol 16 is, of course, as such amenable to a question posed by a national Supreme Court in a live case, which would require a clarification of the 25-year rule as presented in Winter. As such, if the requirements of Article 1 of Protocol 16 are met, there is nothing in principle to preclude the court from giving an answer. I would like to conclude by giving Professor Zil-Smit sort of the final words before I close proceedings. Please, Professor.
Well, thank you very much. And I almost want to say on behalf of the audience, I found these last answers very, very insightful. I myself have tried to remain open to the abolitionist possibility while dealing with the doctrine. And I think the example that Judge Turkovic just quoted is really a perfect example of where the court has done the same thing. My criticisms of Hutchinson were, I was trying to be contextual and looking forward, and I'm very encouraged by the response that we've had, that this is not the last word, that there's a lot of scope for maneuver still. So thank you from me personally, and I'm sure on behalf of the other audience for the court, to be so open and frank with the public is deeply appreciated.
Thank you very much, Professor. On behalf of the organizers, I thank all the speakers and Professor Harcourt, who is now on his way to North Dakota. I thank very much members of the court's IT staff who are here with us in the room, and all participants who have been watching from afar. Thank you very much, and have a nice evening.